Morning, afternoon, or evening. This is Stephanie Joy with Joy Disability. You're about to see a replay of the live Q&A of a recent session. They are generally 1 to 2 hours long every Wednesday at 1 p.m. Eastern Standard Time on this YouTube channel. So I hope you get a little tidbit of information out of it. Otherwise, maybe I'll see you at 9 a.m. for short little workday shares that we put out there on a daily basis. Take care. Hey guys, hope you can hear me. I'm just getting the comments up here. I've been running. Yeah, I'm so glad I made it on time. Anyway, I hope you're all doing well. All right. So I want to scroll to the top. I see a bunch of people posted early comments. That's awesome, guys, because that gives us something to start out with out the door. So I appreciate that. Kevin Johnson, were you first last week too? You're like the early bird. I love that. Okay. I just want to make sure everything is kosher. Can you guys hear everything? I think you probably can, or you'd be saying, Stephanie, we see your mouth moving. Nothing going on. I just wolfed down some rice and beans for about 3 minutes before I turn this on. Yeah, okay. So, and just by the way, if I'm moving around and you see a bandage on my head, I got a little bandage on my head, okay? All is fine. It's what you would imagine it is, and all is fine, or will be. Okay, so let's hop to it. So good to see you guys. It is Wednesday, the 28th, 1 p.m. Eastern Standard Time. We start with Kevin. Hi again, Kevin. Good to see you. How well does an ALJ hearing go? This is my first one. That will depend on what your outcome is the way I look at it. So it really depends. I will say the ALJs tend to be 99% very polite, very nice. They're not going to give you a ton of time. That's not the goal, although they're going to give you the opportunity to speak. And usually they ask you questions. If you're pro se, Kevin, they will ask you questions to get some of the day-to-day that's going on with you, so they can add that to what's in the record, right? And by the way, I don't have the green screen today, guys, either, because I just didn't have time to put it up. I'm a little clumsy, and so if that's what you mean, I think maybe 2 times I had what I would consider to be rude judges. I think it was only 2. And the 2 I'm thinking of were both lady judges. It's kind of sad. Kevin's going on to say that he's so frustrated with the SSA. They just deny everybody not looking at medical records, or just deny you on GP. What is GP? I'm just going to say they don't deny everybody. And this is from the waterfall chart from probably 2 or 3 years ago. Percent when, if I recall it correctly, on initial. And that hadn't really deviated much. And then a smaller amount of those that appeal, which might not be the ones that were denied, because I know I see people who applied, were denied, and never continue on. I know this is like weird, guys, without the green screen. 15% at that time, the waterfall chart said were, 1 on appeal at a recon level. And then, and this is the funny part, I can't remember the ALJ level, but we always see things around up in the 60% level. So it's 60% of whatever's left. So I don't find that to be too terrible, particularly when there are plenty of people who they think that they are disabled because they can't do their prior job. And they don't want to do other jobs. So they think that's the definition of disabled, and it's not. Okay. All right. And I'm just trying to see if this can be not so flappy. Okay. So I don't think they deny everybody, and certainly not in my experience, but you have to know what you're supposed to be submitting that will make the best evidence for your claim, right, Kevin? And if you don't know that, or if you do know it, but you just aren't going to be able to get it because depending on your age and everything, it is a very, very high standard, because remember, you have to prove that you are unable to do even the simplest, most unskilled, sedentary, easy, non-thinking, low-stress job in existence. That's a big bar. Okay, physically it's next to nothing, and mentally it's next to nothing. So it's very hard to prove you can't do it. I know the thing that I will say that I disagree with the most about the SSA might be the fact that you might be able to do that kind of stuff. You've got the brains, you've got the physical ability to sit there. But do you have the ability to do it 8 hours a day, 5 days a week? And that's where I think we miss the boat a lot of the time. Because it seems like, and I'll blame this on the SSA as much as, anybody presenting evidence. It is easy to show that one can lift 10 pounds or even 15 here and there. It's another thing to come to the conclusion that the person can, therefore, because they could do it for that 2 minutes in front of somebody, that they can do it 8 hours a day. of course, the doctor's records that don't really emphasize how debilitating something is don't help. So, I mean, I really think that's a large part of who needs to be educated. But of course, doctors don't work in the SSD field. And honestly, their job is not necessarily to help people win, claims. If you notice, in a personal injury claim, I used to do personal injury work on the defense side, and well, on both sides, but mostly the defense. All the doctors that partake and provide juicy information, they're all paid out the nose by the plaintiff to do that, and by the defendant for the defense side. So they have an incentive. That's why it's with the jury. So there's a lot of theatrics, but they get paid thousands of dollars to come testify at your trial. And they are paid for pre-trial involvement, writing the report, then possibly doing a deposition, potentially interrogatories, but I think it's usually deposition. And you have to come up with the money to pay them, or you might be out of luck, or your lawyers will do so if they know they've got a excellent liability case and the damages are there. So there's a big difference between doctors treating you who aren't going to get paid to, present their record. They don't present them, but they send them in. So it's a huge difference. They're not paid to make up anything or take a side. Kevin also mentions that he had a coworker die in 2022. She got denied twice before her ALJ hearing, died before her ALJ hearing. And that is very sad. It is sad how they treat us trying to get SSDI. But you have to remember, Kevin, that that is sad. And I've had people pass away prior to prevailing. And each time they have prevailed after the fact. But you know what? You probably blame much of that might be on the medical providers who provided medical records and in no way suggested that your coworker was terminal. So if you're not terminal and the death is, it happens, but it wasn't expected, even with a relatively unhealthy person. You see what I'm saying? So I'm not sure you can assume the SSA should assume someone's terminal when their own doctors don't even think so, right? And again, if she was a young person in particular, that is where her medical records failed her. They failed her. Because medical records are the foundation of your evidence, and you cannot win a case without decent medical records. Shub, how are you? You're welcome. You're welcome for that. Justin Yu, nice to see you. He says, hi, Stephanie, I don't understand. I asked my attorneys for the file at SSA. They hardly got any evidence. Oh, so you received the file. That's great. I sent them 100. Oh, God, I thought you were going to say you paid them. I was going to smack them for you. I send them 100 of records, and they call my attorney to complain about it. It doesn't add. I think he's going to say it doesn't add up. You send who hundreds of records? The SSA? But you have an attorney, so why isn't your attorney sending the records in? You follow? And the attorney has the power to see that they're right in the file the whole time. So I think might be something you're just not aware of. I mean, I assume you sent your records to your attorney and not to the SSA and circumvent your own attorney. That's what I'm assuming. I'm going to turn this phone off because I can hear the ding. I usually do that beforehand, but like I said, I'm a little behind. I would normally think you would be sending it to your lawyer. He would be in the Electronic Records Express, which I want to mention to you guys. If you didn't see yesterday's, I think it was yesterday or this morning's. Yeah, this morning's 9 o'clock. It's the best news ever. It's like Christmas in May. Really excited. It has to do about the Electronic Records Express and what we can see. But soon, very soon. Anyway, so your stuff is a little confusing, Justin. I feel like somewhere it doesn't add up, but it's probably not the SSA. I'm just saying it like it is, guys. I know some people are like, oh, if you get on YouTube, you have to bash everything about the SSA. There's plenty to criticize, and I do it all the time, but I'm not going to just throw criticisms that are unfounded or unsubstantiated or rare. Sometimes it's the one in a million bad thing that gets like, woo, it's like how bad news travels, but is not the majority by any means. Janelle Barrows, hello to you too. If an ALJ judge stated in the denial letter that there was no change in medication after a certain date, and there was, is that a good reason to remand? I don't know if it'll be considered the full reason to remand, because it'll depend on whether that's harmless error or would have changed the outcome potentially. And the AC, Appeals Council, I believe, doesn't need to find that it would absolutely change the outcome, but they have to find that it was a material thing that he didn't do and that it could have potentially. So I think that could be good. If that was a medication, I mean, the fact that he's pointing it out that it hadn't changed makes you think, well, if it had changed, he would not have put that in there. So he must find it meaningful that it didn't change, or else why would he take up ink? And therefore, the fact that it did change, hopefully in some way that would be in your favor in your case, I think I would put that in an Appeals Council brief. That's something you're probably going to want to point out as a point, as opposed to not doing a brief or not pointing it out, simply because it might be such a small, tiny thing. They don't know that it changed. They don't go in. I do not believe they go in and investigate every statement necessarily, particularly if it's not necessarily the one that everything hinged on. But it's certainly something I would include, particularly if a change in medication, like an increase in something once or more than once during that period of time, which would only happen if things got worse. I mean, if the change is that they were able to cut out something because it's all better, obviously not. Jackman, cross-examining vocational expert, 0 part-time work in economy. I don't know what that means. Meaning you're not working part-time? Okay, that doesn't mean it's not in the economy, because there is part-time work in the economy. Not the kind, but that's not what's considered for the SSD rules. No full-time work, mental illness, 2 jobs, hypotheticals, off-task, medication, interaction with supervisor or coworkers, but I do not see a question, Jack. Maybe it's down further. Oh, I see him down here, Dr. DR. All right, Jack, it looks like you got a little distracted there. Going back to Janelle. How do I correct a statement that was highlighted by the judge from my psychiatrist that wasn't accurate? I think you're referring to the medications, right, Janelle? You don't correct it. If you're looking, well, first of all, this seems a little different than what you said before. There was no change in medication. Are these 2 different instances, Janelle? No change in medication after a certain date, and there was, and that would be in your medical records, and you could even prove it with prescription, although they don't really. You could, you show your prescriptions and how it was changed, and that would kind of prove it, probably. But the judge relies on something that your psychiatrist did say in his records. So you're saying the psychiatrist said there was no change in medication when there was. When you appeal, you're not going back to the judge. You're appealing it to the Appeals Council. And if you have evidence that you didn't submit that would prove it, you might not be able to get it in now, but you can try. Appeals Council generally doesn't take new evidence, but if it's relative to a prior period. So let's say you have the medications printout from the pharmacy that shows that XYZ medication did change. And that's going to be, and it says the date before the ALJ hearing. Maybe the AC would accept it. When you say, but I will say also, the judge didn't do anything wrong if he's taking what the psychiatrist said in your records. So this is the kind of thing. Those medications are supposed to be submitted, your report, right before the hearing, the HA 4633, I think, where you put your current medications. Now, if you did that, it would be in the record, and you could point to it and say, I told the judge that this change, he had an obligation to delve further then, since my psychiatrist seemed to make an error in his reporting, and there you could try that, get that pharmacy record. You can go to your pharmacy by and large and get a printout of everything that was prescribed. And it might even say whether it was picked up or not. Hi, Rat's Nest. Hi, Dimple. Hi, Fredabug. Jackman again. Kelly, is it Kelly Crease or Kelly Chris? Or Kelly Crace? This is Kelly's first time. I'm glad you're here, Kelly. Thanks so much for showing up. So I'm glad you like the videos. Also, we've got La Lulu. Hello, and you have a good day too. Daryl Smith, here we go. How should you be notified about consultative exams? I have 2. One is the day after a surgery from the VA. Well, I'd like to think they do it in writing. Sometimes they call. to arrange this scheduling date, but sometimes they don't. And they're trying to just get them banged out. If you have a problem with one of the days, for instance, a surgery, maybe you can't travel. I don't know what your deal is, but with the surgery, but that stands to reason. A lot of surgeries, you're just supposed to lay low. You could probably get that moved, but you need to call them right away. Call the adjudicator right away. I would probably fax something in too with the barcode, because I don't trust phone calls. They're not really, you can't prove them. Can't prove what you said. So I'd probably do both. Call because it's quick, and you get someone, a live body on the phone, hopefully, or you leave a message, and then a letter saying, I just left you a message, adjudicator Jones, that I can't make it to the consultative examination for the date of blah, 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 because I will just be out of surgery very prior to that. And I've been advised not to drive or something like that. But yeah, usually the CE exams arrive by U.S. Postal Service, which means they can take forever to get here. I know ours do. Sometimes we get them and sometimes my clients get them the day before. And I usually notify the adjudicator. I'm like, you've got to give at least 3-4 weeks, because mails can take 2 weeks. It's not speedy. And then usually they'll give you one chance and they'll reschedule it. So I would give that a shot and tell her, let's say you're arranging transportation, you're not driving, or you don't have a car and you're gonna have to arrange transportation. You might be saying to the adjudicator, I need 4 weeks because I need to get someone to take off work to take me. And I need to give them notice. You know what I mean? They need to schedule it. So, and I think that their directives must be to allow for one reschedule like that. Sometimes even if you miss it, they'll give you one reschedule, but they're not going to do either way. They're not going to do it twice, in my opinion. I mean, unless you're maybe in a coma in the hospital. No, Jackman, green screen is not on. I know, it's probably better, right? Even though that one time it had all that weird, crazy ash dust floating around. It's not on because I got here. I think you were there, Jackman, when I came in. I was rushing. I just drove an hour from Hazleton, Pennsylvania, for my little procedure. And I had to do, believe it or not, I had to eat something, and I had to do a little bit of cleaning up of the kitchen at the behest of my 16-year-old son, because his girlfriend's, and he did a lot of cleaning last night. We're a little messy here. I said, listen, I'll try. I don't know what time I'm going to get back. And it took a little bit longer than I'd hoped. So I didn't get enough time, and I had to eat something because I didn't have breakfast. I was kind of rushing when I came in here. I think it's do my hair, see? That's why it's so little. Although that's often the case. Kevin, you're 59. That's a good year. Have we spoken about your case in detail, Kevin? I don't know that we did. But you have a lawyer, I think. That's why, right? Daryl Smith says he did notify his lawyer. Still not communicating from the lawyer. And Daryl, that was about the CE exam. Then I would call the adjudicator. I mean, not to interfere, but if you need to cancel the one, I would call your lawyer and tell him, and then send him something in writing so you can prove it, and fax it to him so you have a fax confirm that you sent it to him. And potentially, you could notify the adjudicator yourself. I know you shouldn't have to do that, but I mean, that's why you have a lawyer, but you still got to take care of yourself, right? So maybe do both. Whenever you send something to them, speedy like that, fax, and get that fax confirm back. So if they say, you never told us, you could say, yes, I did. Audrey, hello, Audrey. I don't know that we've met. If not, or is that an L? Audrey says, if one gets Social Security disability for mental health, can they go live out of the country, still see doctor out of the country? Absolutely, yes. Absolutely, absolutely. Mental health doesn't matter. It doesn't matter what your disability is. You can go live in most countries and still receive your check. Do your due diligence on looking up the current list of countries. It's publicly available. It's usually just some of our untrusted fellow nations that you can't go to. Well, you can go there, but the SSA or the U.S. Treasury, I do not believe is allowed to send money there because of their unfortunate ways. Maybe stealing, maybe fraud, maybe whatever. But yes, SSI, supplemental security income, would be a different story. As you probably know, there is, once you're out for 30 days, your SSI is no longer going to be had. Now, I should mention also, Audrey, that you can go live out of the country and still see the doctor out of the country. But for some instances, and I don't want to shoot my mouth off about which ones you have to return every 6 months. I don't believe that is across the board, though, and I think that might not even be before the worker beneficiaries, like your own SSD. But don't let me get into the weeds on the details so I don't misstate it. I'm trying to think of the recent discussion I just had and the details, because it was yeah, you have to come back, given the specifics of that case. It was a non-citizen who was owed Social Security, and that's totally fine. If you worked for it, you get it. In this case, it was a non-citizen. Boy, I'm gonna really butcher it. It might have been that it wasn't her own work record. It was spousal benefits or survivor. I don't know the exact details, guys, but there is a parameter, a set of situations where you can go live out of the country, but you have to come back every 6 months. And I don't know the specifics off the top of my head right now. Okay, so Jackman says, therapist, psychologist says I'm disabled. State doctor says I'm disabled. Well, it's interesting you say that, Jackman, because the SSA will not accept a medical professional saying someone is disabled from all jobs in the entire economy that are under consideration by the SSA laws. They won't say it. They won't accept it because your psychologist is not a vocational expert who can even testify as to how many jobs are out there, what all vocational aspects they require of you to be able to do, what are the requirements of the job. So how on earth can a psychologist say you can't do job A if he doesn't know what job A is, or job AAA BQZ? You follow? Same with the state doctor. They don't ask the state doctor, are you disabled? So you're mishearing it from somebody or misreading it. What they want from either one of them is a description of how limited you are in a variety of tasks that are relevant to being able to work various jobs. And if they have you at a high level of limitation, based on the definitions of limitations, there could be mildly limited, markedly limited, extremely limited, and depending on where moderately would fall into if they use those terms. But the three that I just mentioned are what the SSA uses. Well, including moderate, and moderate will get you nowhere. So it's got to be, for many situations, it's got to be two markeds or one extreme in one of the sections of tasks related to a specific capacity to do something, like to attend to work on a schedule and without distraction and blah, blah, blah. There's like 4 or 5 things in there that are exemplary. And remembering details and work like instructions, that's a whole nother one. And carrying them out and whether they're simple versus detailed. So they don't ask them their opinion on whether you're disabled because they're not qualified. They haven't taken vocational classes. They have no idea what the dictionary of occupational titles says for each of the 12,000 jobs. So now I will say this, if your therapist, psychologist believes you are disabled from all jobs, even though they're not really educated in that area, that's a good start. You don't want them to say that to the SSA because they're going to get tromped on. And I think it sometimes annoys some of the adjudicators. And it will flat out say that is reserved for the commissioner of the SSA, your little conclusion there. But the fact that they support you is 90% of the battle sometimes. In truth, now you just have to know, or your lawyer will know, what, you can give them interrogatories. Some of you guys refer to it as an RFC, which is kind of the same thing, but an RFC is really created by the SSA. It's a medical source statement as to limitations. You will know, depending on your particular facts in your case, what questions you need to know. And you need that psychologist to say markedly or extremely. Or if you're going for a grid, you might not even need marked or extreme. You might only need moderate, if it's in something that would interfere with your old job or your ability to transfer the skills from that old job to a different job. Jackman, Allentown, is that Pennsylvania? So that would be the Allentown, the Elkins Park. Now, where's the DDS? Now that you never drive to the DDS anyway, that's all technology. Allentown is not far from me there, Jack, but I don't like going there. I don't like Route 33. I have to do it pretty regularly, but I don't prefer it. Richard Unknown. Hi, Richard. Nice to meet you. I have an ALJ hearing coming up. In your experience, is it harder to prove mental health disabilities and physical disabilities? My mental health conditions are PTSD, anxiety, and major depression. Proving the disability is not really the problem, Richard, the diagnoses. It's the severity and whether it knocks out every single job. And as if you were listening before, I don't know what time you came in, a lot of people with PTSD, anxiety, and major depression are able to work. They may not be able to work in a high-skilled job or a high-skilled one they did before, or any high-skilled job, or even a semi-skilled job. They might only have the ability to work some unskilled, low-stress jobs, maybe ones that don't deal with the public, or even maybe coworkers. So it's a loaded question because it will also depend on your vocational profile. What was your prior work and what is your age? Education, I don't really have huge concerns on it, generally speaking. Although I do have a case right now, the person is concerned because their degree was just a few years ago. So we will see about that. So going back to it, Richard, if I had to say which one's easier to prove a diagnosis, the diagnosis is pretty much accepted as long as it was made by the appropriate professional according to the standards set by the medical profession, right? And documented as such. So it's going to be the severity. I will say that with physical disabilities, there is objective evidence that can be usually obtained. That would be the MRIs, the X-rays. Prefer the MRIs, guys. X-rays often don't show what needs to be shown. EMGs, CAT scans, blood work. If someone has like a systemic condition, disease process, like an autoimmune or something, that can be very helpful. Sometimes those conditions are seronegative, but they can still be diagnosed in other ways if you have the right specialist involved who is going to, take the time and the thought process to do that. So in the fact that there's objective evidence in diagnostics for the physical is one level of ease, I suppose. But the other ones, a lot of it is going to be now PTSD, anxiety, and major depression. A lot of times those providers are not going to share, even if you beg them to and sign the release and everything. They're allowed to share all the psychotherapy notes, but they are allowed to refuse to, even if you, who are paying them, want them to. And I see that the SSA will say, we don't really need the psychotherapy notes. They're just kissing up to the little carve-out law on HIPAA. Because the truth be told, some of those psychotherapy notes really show how off-kilter someone is. Because oftentimes the mental status examinations, which are supposed to be available, they're not supposed to be able to withhold those. They're going to say everything's stable, 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 within normal limits, stable, stable, no complaint, looks fine, sound judgment, blah, blah, blah. But when you get into the conversation, you find out that the person had a road rage accident 2 weeks ago, maybe has a ticket. And I would say, by the way, legal troubles when it comes to mental health can be helpful evidence. It's objective, even though it's not physical, because it's usually created by the police department, who has no interest in creating mentally unstable people who lose it and do inappropriate things. A lot of different ways you can kind of come at it to get the extra evidence. But for the mental health, again, it's always about, and with physical, very, very consistent, robust, thorough, repetitive treatment. Like you're making it your full-time job. And with mental health, usually it's weekly sessions, and usually it's medications, and usually it's the medications are not working well, and so they have to keep trying new things. Because if the medications are working well, some may say, well, then you could go get a simple, unstressful job. But if the medications they work enough to allow you to function at home in a protected environment, that can be different. We've talked about that elsewhere. Some of those, the importance of if you have a need for a structured, controlled environment, not institutionalized, that's a whole nother thing where that would be probably simple. But if you don't, how are you handling your lifestyle? Because if you're out going to parties or having fun or going, skiing with the guys whenever you feel like it, but you claim all these things, it's going to be not optically taken very well. Because, arguably you could probably do things and you just don't want to. But if you're not doing those things because you really would get, you can't go that long without needing to decompress and maybe be by yourself, need to be this jacket is pulling on my neck, need to be, ability to extract oneself and go to a quiet place, like all those kind of things. And those are things that obviously your therapist should know and should be writing about. Yet if the therapist chooses not to give you those psychotherapy notes, and who knows, maybe the psychotherapist was never taking any to begin with, just kind of going like this, you can have a harder time. I think in the instances where I get psychotherapy notes, they're usually very helpful, usually, to give a little detail and context. Richard says that he also has migraines and chronic fatigue. Yeah, so if you have chronic fatigue, you're seeing a chronic fatigue specialist, right, Richard? Migraines, you're seeing a neurologist who specializes in migraines, right, Richard? And you're seeing them as regularly as needed. And what is the treatment for the chronic fatigue? What are the efforts to alleviate it? Those are tough ones because you can't see them. But also, we talk about journaling. That can be really helpful. Not to make you feel good, journaling. I don't mean it for mental health purposes. I mean it for things like, if you have chronic fatigue and you're sleeping a lot, maybe the hours that you're sleeping during the day. You could even do the hours at night because maybe that's a time when you can't get to sleep, which is causing the chronic fatigue or contributing. Migraines, particularly important. Note that a migraine versus a headache, don't confuse the two. I think it looks poorly in records. If you go to the doctor and tell them that you're suffering a terrible migraine at that moment, it's not going to look very credible because generally people with migraines, when they're having one, are in bed, potentially with a vomit bag, in the dark, cool room. So you wouldn't be going to a doctor appointment. You just wouldn't. You would be canceling it and rescheduling it. It's just, the way it is. Maybe it would be a virtual appointment. And you want to journal, like in a calendar, which days you are out and out of commission. Because if you're able to drive when you have an alleged migraine, one would argue, well, then you could do certain things. Driving is a high function, it is. It's able to pay attention, see, hear, move your head. There's a lot of stuff going on, a lot of thinking too, which is kind of inconsistent, some might say, with a severe migraine, one that you can't work with. Remember that simple, unskilled third grade job. Always go back to that when you're trying to figure out, particularly if you're under 50. Try to go back to, can I do a sedentary sit-stand option job that a third grader could do, based on the lack of skill needed. And if not, then you want to develop the proof and evidence on an ongoing basis of that symptom that you have that would prevent that. That's the way I look at it, guys. Wow, Daryl. Daryl says, this is Daryl Smith again. I was on my SSA account. That is how I found out about the CE exams. So you haven't gotten the mail either. See, this whole thing about snail mail being used, obviously that's all they had back in the day. I would really like to think they would use, did you get an email or a text saying check your SSA account? There's something going on. Did you get that from the SSA? How did you know to go look? Was there a prompt, or do you just happen to look all the time, which a lot of claimants do because it's their one and only kind of connection, right? George Graham. Oh, you got a new picture, a praying mantis. We just found some praying mantis cocoons, if you will. I don't know if that's the right word, at that little place we have over in Perry County. And they'd gotten dark brown. I don't know if that meant they were going to hatch or already did hatch. But there was one that was lighter. I wanted my husband to bring it inside because I remember we once had one when I was a kid on a plant inside. And then it hatched. And all these little cute, little tiny, it could be hundreds of them, of praying mantises came out. I thought it was really cool. But I was kind of a farm girl, so I thought a lot of things that would freak people out were cool. And when they get big, I would not be thinking it's so cool. I protect them and everything. They're supposed to be good for the environment. And I think they're fascinating. But when they get this big, they can probably pinch you pretty hard. And did you know, I believe it's true. Correct me if I'm spreading disinformation here. I think the female, after doing the deed with the male, I think she bites his head off. Where? I don't know what that's about. It's pretty interesting. I bet you some human ladies wish they could do the same. Just kidding. Okay, Lionel Mandrake. I haven't seen you in a while, have I? I just got denied in reconsideration. And again, I'm sorry, Lionel. They did not have or consider my most important records. I spoke with the DDS and she confirmed records were not sent. Should I ask for a reopening? No, you're not going to get a reopening. That's why you appeal. It's going to be an appeal. And why did they not get them? Refresh me, Lionel. Did you tell us this already? It almost sounds familiar. So maybe we spoke more recently than I thought on here. If you didn't send them in, that's why they didn't get them. It could be that they ordered them and your provider just didn't comply with your request because it's signed by you. You know, when the SSA sends it in, it's signed by you. That's the 827. I would get them. You're denied in reconsideration. So you're going to ALJ. I'm assuming you don't have an attorney or a representative. I would gather those records myself. I would send them up to the ALJ saying, I understand the DDS didn't have these. The ALJ, once you file that appeal, should be getting you a barcode. You should also ask them for a copy of your, once they get it, well, you want to get it when it's exhibited by them, but then that holds you up because if they don't exhibit it for a couple months, then you're kind of like hands tied. So you could go, you know what you could do? Go directly to the SSA and demand that they email you. Demand nicely, of course. It's a request, but technically they have to do it. That they email you a copy of your entire folder. They get the whole thing. When you start sending things in, you know, maybe getting closer to hearing, maybe ask the OHO to do the same. Which brings up a really great point, guys, which was in the video, I think is this morning, because it came out yesterday, I think. I was like so excited. The SSA is, I'm just going to repeat it right here. We used to only be able to see in initial and recon, only your medical records section and section E. We couldn't see your DDE, your disability determination explanation, which would explain why did they deny on initial? Why did they deny on recon? No. We had to so you couldn't actually make your recon potentially work better for you by knowing what they were lacking or what their opinion was. You know, you have to get your doctor to maybe focus in on something different. As of June 7th, they are beta-ing our access to A, B, and B. For some reason, not D on initial and recon. I'm so excited. Last time we got any kind of access at any stage before actually going all the way to the hearing was in the fall of 2020. Boom, it was the biggest miracle because now we could see on initial and recon at least what evidence was in. Us representatives, not you guys. And that was great because then you could do more work on initial and recon. It really provided for a lot more hands-on activity without having to call the adjudicator, get them to call you back. Oh, what records do you have? What records do you not have? So this is going to be pretty huge because the DDE is actually the rationale of why they denied you. You know how your denial letter says pretty much squat. It's just canned. It doesn't really say much. The DDE is all the meat behind it. So it's going to be really important. I was so ecstatic. I can't believe we had to wait 5 years for them to get the next part in for us, but very excited. It's good for you guys. If it helps us help you, right? Justin, you. SSA was complaining about it. My attorney said they will talk to me about evidence a month and a half before my hearing. Lovely. I see. It seems like my attorneys are dragging this out. I got mad to attorney. Yeah. All I can say is I don't think it's appropriate to wait until 6 weeks before a hearing to talk to your client. You know, it's supposed to be something that's going on all the time. All the time. You know, my clients, as annoying as it is, I'm sure, they have a message thread in our portal where every time they go to the doctor, they tell us who, where, which office, for what, and what date. I always say, just do it right after you're done with the appointment. That way you won't forget. And we have everything, boom, 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 on an ongoing, constant basis. So it's just, I don't know. People do things differently, guys. That's all I can say. Super secret. Super secret. Typically, how fast are 100% PNT expedited claims? Not very. Step 1 was completed for me in 3 days. That's good. That one's 3 days for everybody, though. It's the section 3, step 3, and beyond. And I would say generally step 3 for the most part. So it's expedited, I think, as in they take you faster. You might get priority getting an adjudicator, although I've seen that bluff too. I mean, don't even get me started. They can't, I mean, they can only expedite in that they don't make you wait in line behind others for certain things. Okay. Which I think is great. But they can't say, all right, we're going to do medical evidence gathering for this fellow, and we're only going to give it 2 weeks because we want to expedite this. Well, 2 weeks, if your medical providers haven't provided the evidence yet, you don't want them to go to the next step because that would be a denial. You want those records to get in. So there's an extent to how much it can be expedited. And also, if you fall into this horrible trap that I've seen, and we have one right now, we have a congressman on it, but it seems to be bizarrely not working out so well, which is a first in my entire history of working with Congress. And this case is just really getting old. And we didn't have an adjudicator for the longest time. And I'm not even sure I have an adjudicator now. It's hard to tell. And usually you can tell inside because they're doing something, but they're not really doing anything. Yeah, Jackman, there's no way I can give you, what's the chance that you want at your ALJ hearing? I don't know your case. I don't know you. I don't know your ALJ. I don't know what questions were asked at your hearing. I don't know any of your evidence. I don't know what was asked of your vocational expert. I don't know what was asked of you and how you responded. I know nothing. Okay? I don't know your vocational profile. I don't know anything. So I can't tell you what's the chance of winning. Can I? Sorry. But I can't. Janelle says that she said, this would be the judge, Janelle? I avoid treatment. But I said, I don't like going. But I go to every appointment. Oh. When she denied you, Janelle, and says that you avoid treatment. You have to, like, if you're not going to appeal this to the appeals council and you're going to refile, assuming you have that option, none of this is going to matter because you're going to put it to rest and just eat it. But if you're going to appeal, you could bring that up and say she mischaracterized based on no substantial evidence that I avoided treatment, but I have never avoided treatment. In fact, I go every time despite not liking going, having an aversion to it, but I do not avoid it. You know, you could say that. I don't know that that's going to be a flipper over, but you know, with whatever else you might have. I know there's a couple of videos from a while back where I went over some of the things to look at in your denial letter, your decision denial letter. Can't do this on a national recon the same way, that you can use it to see if you have an appealable issue, at least a certain kind of appealable issue. There's probably a gazillion others, but that would probably be under ALJ hearings playlist, maybe. Hi, Trish Wade. Good to see you. Okay. Kelly Christ without the T. Gotcha. My guy. Okay. You're welcome, Kelly Price. Janelle says, okay. Tell me if I'm getting this right, Janelle, now. She says, the changes in my medical record before he made his decision, my lawyer probably didn't provide it. Well, here's the thing. If the judge already closed the hearing and didn't leave it open, then technically the judge isn't going to be accepting it. So whether your lawyer sent it to waste his own time or not is another story. I probably would have sent it either way, just because sometimes they just kind of reverse themselves and go, all right, let me get it in here. But that could be a double-edged sword too, because imagine this. They're intent on denying you. You send in this extra evidence. Now it's part of the file that they still denied you on. Whereas if you kept it, it would be new evidence. Thinking. And if it's dated, if that correction, Janelle, is dated, kind of alluding to what I was saying before, dated before your ALJ, well, certainly before your hearing. It's a little more difficult when it's after hearing, but before decision. And you can explain that you could try to explain why you didn't have it sooner, or why you didn't tell the judge that the psychiatrist was fixing the medical record to fix a correction. So it really depends perhaps on when dates fell with regard to the course of events. But you could try to submit it because he is changing a record from before. So it's actually retrospective before the decision. I would give it a shot, you know, with the way we said it before too. Pardon me, guys. Platinum Swords. A new subscriber, I think you're saying. That's nice, Platinum. Thank you. Nice to see you. Nice to meet you. Got a question. Why is the delay so long for reconsideration? I have everything that was asked plus a FCE where I was deemed crippled. Well, if you're crippled, you're in a wheelchair. And if you submit records that prove you've been prescribed a wheelchair and that you need it for all the time, you will win. But maybe that isn't what's submitted. An FCE doesn't usually say he's crippled. So I'm just saying you got to be careful with your words. The way you're the subject matter of the FCE, which is functional capacity exam, guys, which is generally, it's not the same as what we're usually referring to. Usually people that do FCEs are doing it based on other questions that are not as relevant to the SSA. So it's not as helpful as people think. But be careful of your words. You know, when we're the subject matter of something, we kind of have a subjective tint on how we read things. And then we paraphrase them differently in our heads. And that might be where the word crippled comes from. crippled is not really like a medical diagnosis, I think. It might be, you would probably have to use the actual, have medical records showing, his legs are lame and cannot hold his weight and he has to be in a wheelchair, or however it is that you're crippled. The delay so long for reconsideration is probably because they had a hiring freeze a few years ago. That probably occurred at the state as well, where they bring in the adjudicators, and people are waiting a long time on initial as well. So it's not just recon. You said, I have everything was asked. Does that mean what? Did you get all the medical records in? Did you get every single medical record that should have been gotten? It could be that you don't have an adjudicator, and depending on how long is long. Is it a year already? Which is horrible, but I've seen it. It's not even rare now. I think they're starting to get up to speed a little bit, thankfully. But in fact, I think I have one that just, wonderful client who texted me actually when I was at that doctor's visit, that place. And so I was kibitzing back about getting that federal quality review, which is the language you've all been using when you've gotten it. And that's kind of new language. So, and it's because I think it was up in the SSA online portal. They don't send us a letter about it. So that's interesting. And of course, you want to know if that's good news. I go, I think it could be good news, because technically you shouldn't have to have a quality review unless an adjudicator has made a decision. And I tend to think that they tend to quality review awards more so than denials. They need to make sure, they need to do a sample amounts to kind of keep an eye on whether the state disability examiners who are outsourced to do the federal work are doing, this was to apply the federal law, if they are actually following the law. So step by step and all that, and getting all the medical evidence and all that business. So it's just a little oversight to make sure that, it is money's out of the fund, and they want to make sure everyone's following the same rules, and that no particular state adjudicators are pulling some fast ones to get all their people in their state with some money, because then they can spend it in the state, and the state can do financially much better. In theory, there's always money behind every question, right? And everything that goes on. So I think it was just funny because it's federal quality review, and I'm like, oh, I keep hearing that terminology from people, that comment and stuff. So she got one. I guess that's the new thing. I do the only thing I like about it is that they're telling her it would mean that she's had a determination made. And it's been a long road. It's been a long road for her. We are on initial, but it's probably been a year. Now, we've been really busy during this year. She's really good with that portal, sends the messages every time she goes to a visit. And I will say, this is a person that moved from one state to the other in the middle of the case. Can that cause a little brief hang up? Yeah, sure, of course, for sure. But I think it was just slow anyway. But that made it a little bit longer. But when you got to move, right? And she was really diligent about not only telling us in the thread that is designed for this every time she had a visit, she also would print out the progress note. And every time she did it, I shot it up the same day, or if I happen to be, going through the inbox a couple days later, me or one of us would get it right up to the adjudicator, because even if the adjudicator is on vacation or whatever, I want them to have everything possible up to the point of their adjudication for the best chance of winning on initial or recon, rather than just, the application's in, order the stuff. They order it, it's not enough, and they don't get anything new during those next 6 months. This person could have had an MRI, could have had this and that, and I want them to have it. So sometimes we actually order them. Sometimes we, we work with the patient with their patient portal and make sure we can get certain things there. It's not necessarily a substitute for the official ordering, but it works at certain times really, really well to help keep that adjudicator apprised of what's going on. It's really important. Tiger Bite, good to see you. I got the dreaded final non-medical review, then denied all on the same day. PTSD and a bunch of other ailments at 61 years old, not even a CE exam, extensive med recs with VA. Yep, P&T. Tiger Bite, refresh me. Were you initial? And did you have an attorney or a representative, or were you, working on it solo? I assume, Tiger Bite, you have physical problems, so hopefully you included them in your case. I'm sorry about that. By the way, guys, she says, I got the dreaded final non-medical. That's different from that federal quality review we're talking about. We have a bunch of interactions and going back and forth with one another here, as well as some standard like 9 a.m. videos that are, in the library from me over the last at least year and a half, when they first started telling people, we've sent your case to non-medical review. Well, to send a case to non-medical review definitely implies that you were found disabled in the medical review, because there's no reason to go to non-medical review and see your money situation. Do you have enough credits? Which was done, by the way, in the beginning. But sometimes they like to double confirm at the end. I get that. But there'd be no need to do that if you failed. I don't mean that in a bad way. If you did not prevail in getting a finding of disability to begin with. So to tell people that they're going for non-medical review, everyone was like, yay, yay, yay. And it sounded really good, because that is what that means. It means to stay a non-medical review. I don't think it's reviewed at all. I think they're just saying, we send it back to the field office, you'll hear from us soon. Then say that. They shouldn't be saying non-medical review. It's appalling. So as I tell people now, I'm like, don't think that you prevailed because you're going to non-medical review, because they're sending that to both the winners and the losers. And it's terrible. And it's been since like, where we at? End of 2023 is when I first noticed it. First, I was very excited. Oh, they get to know that they won, and they have to go to non-medical, because there is a letter about that. That's an actual letter, paper. You're golden. Well, pretty much golden. But when it's in your SSA portal, it means nothing. Yep. I'm so sorry, Tiger Bite. Again, I forget if you had a representative. Want me to? If you do not, because I'm not going to do anything with it. Somebody who has representation, that would be interference, and I'm not going to do. But if not, reach out to me. Go to this thing here. Whoops. If you go to the Joy Disability site, go here. I'm plugging it in, guys. The link. Then it should be there someplace. Just write in the comments when you comment that the Tiger Bite name, so I'll know it's you. All right, and that they can send it right to me, and I'll go through it with you. But that's, again, I can only do that if you aren't represented, because it would just be an interference with that relationship, and I'm just not going to do it. Justin, you lost patients with attorneys in SSA, and I sent SSA all patient portal records that they did not get or have. Sometimes you just got to do what you got to do. Sometimes I'm very disappointed in the work processes of some of my colleagues, because they are not, I don't know, I just don't even know how they can do it and not get themselves in trouble with their bars. I guess because nobody complains, but all right. Daryl Smith. Surgery is removing a mass from my mouth. I found out about the exams on my SSA account. The first exam is mental health. Ooh, so I can imagine, Daryl, that you might not be able to be traveling or going out and about after that mass is removed from your mouth. You could have a lot of pain issues. You might be on pain medications, short term for that. I don't know. Speak to your doctor, but also, if you have to get a reschedule, just do it now, so they can, not be paying the consultative examiner when you don't show up, because they're going to probably have to pay a no-show fee. So you don't want to do that. And I would tell them as soon as possible. That's what I would do. Hi, Gray. How are you? I don't know if we've met. Sorry. I don't remember the name. How long after CE exam should you expect a decision? I find that they are usually pretty forthcoming after that, but not always. So probably the majority of the time they're within a few weeks, but there are exceptions. For instance, maybe they had reason to believe that you had some MRI. Maybe you said, I'm getting an MRI in 2 weeks. And they go, oh, let's just leave this open so we can get that. There could be reasons why it might take longer. All right. Oh, you emailed the lawyer. Daryl Smith emailed his lawyer. That's good. At least they have that form of communication, even if they don't have a portal way. You have a copy of the email, so that's good. Let's hope they do what they should be doing. Did you tell them that you need to not go to that one, that you need that rescheduled? And just make sure to go to the first one. That'll certainly show that you're kind of credible with it, right? D. Hi, D. Hi, Stephanie. I am 53 years old. I had a heart transplant. Did we talk? We recently discussed heart transplant. Was that you, D? And my case is in step 3 phase. Caseworker on my case said like 100 plus records, meaning pages, That's not really that much. Was sent over. How long does it take to review the record? That will depend on how fast they are, how thorough they are. Everyone reads at a different rate. So I really can't say. Is there going to be more stuff? Are you continuing to treat? Do you need more in, et cetera, et cetera? So it really depends. That's so case specific, D. But I think I just did an extra video on the heart transplant thing, D. And that must have been from you, because were you the one talking about it last week? Or was that somebody else? Because I thought it was important because there is a listing for heart transplant. And assuming your heart transplant was in the last year, there should be pretty much an automatic 1-year grant of disability. That doesn't mean you want it to be closed period and to be ended in a year. So you have to actually prove that you're disabled despite the transplant working out relatively after a year. So you want to always use all of your other impairments, which I presume you have at 53. Okay, that you have some physical, maybe mental health, whatever it is. Put them all in there. D, put them all in there. Because you just have to remember at 53, if you're going to go by a grid, you have to prove that you're not even able to do light work. You can be able to do sedentary work and still prevail, but you have to prove you can do no more than sedentary work. And you can't do your prior job, so hopefully that wasn't sedentary. Are not able to transfer the learned skills from that prior work to another job that you could physically do. I have my fingers crossed for you, D. With the heart transplant and with the case. You take care of yourself, D. So blessed. Is 54 during the hearing and now 55 and waiting an answer. Do they take that into account that I just turned 55? In many cases, yes. There's some parameters. There's an SSA. I want to say it's some sort of palms on this. But yeah, if you are closely approaching age 55, in many instances, and there's criteria on this, but I want to say generally speaking, but there's exceptions, so you have to look at it. If you are within like a couple months, 2-3 months of 55, the judge can treat you as if you're 55. That means if you're only going to win at 55 because you can't win at 54 due to your RFC being, say, light, then you'll be found, if everything goes your way in this regard, disabled probably as of whatever day he picks. That's a couple months, but not too far before 55. And it might have to be before the hearing, I'm not sure. So you won't really get back benefits. So just be prepared for that, but you'll have your perspectives. So there is that. So yeah, he's going to take that into account. Most likely. Tiger Bite therapy every week, extensive notes, different meds for anxiety, depression, anxiety, etc. Yeah. Okay. Kelly Christ. Denied by ALJ, originally filed in California at age 58. Denied by ALJ, originally filed in California at age 58. Now reapplied 2 weeks ago at age 60. From Michigan, moved here, had to move in with my mom. Do they give consideration for lack of records for gap in insurance? You have to show them there was a gap in insurance. You have to explain it. And you still have to prove that you're disabled. So it would just potentially mitigate the gap. How big is the gap? Did you get Medicaid? You know, what was the reason for the gap? You said no insurance. It looks like insurance. They can consider it for sure, but you still have to prove you're disabled. You can't just not go and say, I don't have insurance, find me disabled, even though I have no evidence. So you still have to do all that. Okay. I mean, you reapplied 2 weeks ago. You have time. Hop to it. I mean, if you still don't have insurance and you're still not going, then you're not going to probably be able to prevail. But you have time to go, get that insurance, state insurance if need be. You can do this, Kelly. Dia, I have 12 questions for the medical examiner, starting with, would you agree? Is that appropriate? I have no idea because I don't know what your issues are. What if he says, well, that will depend on blah, 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 blah. But it could be. It really depends. Is it true, doctor? Would you agree? And again, the rest of it is but I think it's okay if you're talking about it as a good preamble for a question. It can be fine. Particularly if it's so obviously agreeable what you're going to present to him, right? Michelle M. Hi there, Michelle. 56-year-old, severe scoliosis, humpback, have seen a lot of specialists, went for consult this month. Pain doctor said I'm a mess twice. Did he put that in his record? Michelle wants to do, he's got a part 2 someplace. wants to do, I'm going to have to jump back up. Remind me if I forget, guys. 10 plus injections every 3 to 4 months rest of my life. Wow. I just got a positive x-ray for lung edema related to early congestive heart failure, which is a contraindication for what? The injections? Well, SSA or SSD look down on my case if no injections. When there's a life or death reason like that, not even a life or death reason, when there's a good reason for it, Michelle, they're supposed to take that into consideration. So don't let that get to you. You just got to make sure that you have it in those records with the injection doctor while you're not getting the injections. And from the CHF doctor, how it's indicated that you should not be. Speak with them specifically and say, can you just, explain to me, maybe even do it through a message in the portal, and maybe he'll respond via message, why the injections are contraindicated given my lung edema or my CHF. And that should be strong evidence as to why not. Okay. And then, of course, you're going to have all those diagnostics and such with regard to your scoliosis and the severe curvature, right? We were going over this, weren't we, Michelle? Or we were going to? I forget what we were going to do. Was it an eval and we were going to speak, or was it a consult? And am I slow on the ball, or have we just not gotten there yet? Feel free to email me and refresh me. I've been out of the office all day until this day here. Till now. I'm Williams. Good to see you. This is our big winner of a couple weeks ago, right? Good afternoon, Ms. Joy. Hope you had a great Memorial weekend. Yes, it was uneventful. Thank you. Can't find the review time frame on my award letter, SSI. I'm 56, limited education. Yeah, sometimes I don't put it in there. You're thinking, he's asking about a review period, guys, like a CDR, when you might expect it. At 56, he probably has a CDR diary date for sure. So you can try calling the SSA and asking them to look up your diary date for you. They should be able to do that because everybody gets one. All right. So good luck with that. Okay. Jackman is going back to the off task up top. I'm not sure what that means, Jack. Okay. Michelle says she accidentally put, that she was 56. She says, I wish, but I'm 58, almost 59. Yeah, you and me are close in age there, Michelle. Lionel says, is it prudent to ask for reconsideration, reopening, and ALJ appeal at the same time? It's not even possible. I mean, you can ask, but it doesn't exist. So if you're denied an initial, you go to recon, period. If you're denied on recon, you go to ALJ appeal, period. You don't reopen because you don't like the way they reviewed evidence or some of it was lacking. That gets addressed on appeal because now you have another chance to present that evidence if you left something out. Okay? Sound good? Daryl says his first CE exam is within 1 week. Yeah, I know that's short, but if you can go. I mean, you have to do it eventually. The one with the surgery, Daryl, is the one that I'm a little more concerned about. I mean, it's not like you're working and can't make it, right? Now, if you had an important doctor appointment at the time of the exam, that would be another reason. Like, doctor's appointments are hard to get for many of us. And if you had one and they went and scheduled you there without conferring with you, and you happen to have a doctor appointment, you could ask that to be rescheduled. I mean, I think it's valid. Like sometimes you have a specialist appointment and you're going to have to wait 6 months if you don't go to it for the next one. It's really bad, right? Dimple. If the VE claims that jobs are available, do they provide example of said jobs that pay at SGA or above? Yes, because minimum wage presumably gets you over SGA, although I'm not so sure anymore. But remember, it's full-time work is SGA too. So if the VE claims that jobs are available, yes, they provide example of said jobs that presumably, because everything has to be at least minimum wage. And by the way, if you're in some place like California or wherever it is that they have a $15 or $20 minimum wage, good luck. Now you can't even barely get a job and get decent hours without going over. I'm not sure if they realized how many people they screwed over with that artificial minimum wage. Definitely some disabled people. That was California. But yes, they do list the jobs. They give the DOT code, which you can look it up, and you can see what all is required of that job in terms of physical and mental capacities. And that's how they came up with it. Spooky says, Spooky Flow, if you have a physical impairment that is visually apparent, can photos of said impairment be used as exhibits in a case hearing? Not very usefully. You could try, but what you would probably want to do is send them to your doctor and let them come out in the medical record, because you sending it, like, hey, I got my third cousin to take a picture of my, let's say it's a scoliosis on my back. I had a family member, who had that issue, and this is like 15 years ago now. And I even said to the judge in the hearing, Judge, if she just turns her back, you can look and see. And the judge did not take kindly to that, because it's not really medical evidence. That's her, observation. So sometimes you just want it to not be said and just show it, not like obviously. Like, for instance, if you have a really bad limp, you might want to be seen walking into the room. And you can do this on, you could manage this at a video hearing too. You need to get up and stretch, and your limp will be apparent. Right? A lot of people need to get up and stretch, particularly if they have a limp. And then you hobble back. You leave. You don't take it. You don't take a recess. You just say, Judge, can I stand up for the next couple of minutes while I'm talking to you? I think you'll still be able to hear me, or whatever. So again, some exhibits do have photos because they have the films from the objective diagnostics in there. The judge cannot interpret those. It's got to be an interpretive report by a radiologist or whoever else is qualified to do that. If it's a visual impairment on your face, for instance, the judge is going to see it during your video hearing, because you're going to have a video hearing, right? You're not going to opt for phone. I mean, if you and by the way, when you send it in, it's going to be scanned in, so you're not going to have like a beautiful photo and all the same detail either. So remember, it's going to be a little warped. And you don't suggest what's the exhibits per se. You send it in. And again, if it comes in through your doctor's records, when they order the doctor records, or you send in the doctor records, it's kind of like a way they can't really take them out, because it's part of the medical record, versus you sending it in, like, because your cousin Vinny took the photos. And they have and because also they can't authenticate the photos you sent in that they're really of you, because they don't have the authenticity of medical records from your doctor. Okay, so it's a little bit of that too. Neolog, good to see you. Long time no see. I was approved for SSDI at 55. I turned 61 this month. All right, 6 years later. Still treating with pain management, nurse practitioner. My diary said not expected to improve to 5 to 7 years. Should I expect? I was approved for SSDI. Oops, he said it again. Should I expect a review? Well, they're going to look at it. They're going to see. They might bypass you. I would think that's very potential, or send you a short form. Do you still see I hope you still see your primary care physician. You said nurse pain management, but primary care physician, a PCP, or whoever it is for your family care, the one you go to for your annual physical, they can be, that's a place you can complain about your ongoing symptoms. They're supposed to ask you, right? So consider making sure you follow up with those things, your annual, maybe it's more frequent because you're 61. If you have any other problems, that are not so much pain management, could be cardio, all those things can come into play. So just stick with it. But if you have not improved and you know it, and you have not slacked on your follow-ups, doesn't mean they have to be as robust as when you prevailed, if things are now status quo. But, sometimes also neolog updated diagnostics would be warranted regardless, because after 5 years, if you had, let's say, a musculoskeletal problem, and that's what the pain management is for, they really should be taking a look at inside there, instead of just treating you straight for 5 years with, injections or opioids, and not checking to see where it's at. Is it worse? Does it stay the same? What if it's getting worse and it's about to touch a cord and paralyze you? You know what I mean? Like, there's just obligations, I think. Brandon H. I have a diagnosis for autism, ADHD, anxiety, and depression. Weekly therapy for 3+ years. I'm in step 3 with a CE scheduled for the 5th. I'm so scared they will deny me. I have a diagnosis for autism, ADHD, anxiety, and depression. So much is going to depend on your vocational profile. A lot of people with those diagnoses and all of them together can do simple jobs. So you're going to have to show that you are different from them, that yours is worse. The symptoms are worse. I have to look at something real quick, guys. Okay. I was just making sure no child is left stranded and I have to go pick them up. Heather W. And by the way, Brandon H, I don't even to make light of that. I know you're scared they're going to deny you. Sometimes it's a long marathon. Your age is going to make a huge difference. And if you have any physical problems, those are things that you should certainly be working up to. A lot of times when we're young, if we have the mental problems, we don't have physical problems yet. Who wants to ask for that ugly gift, right? But those are all things you got to kind of think about. And really think about the kind of job and figure out why you can't do it. I can't do, say, folding laundry in a basement. Depression is not generally going to be something that allows us to say, can't go to work unless it's severe enough to literally take us out of life. And I don't mean like in the most drastic way, but severe depression versus mild. Mild is like, we're just not happy. Well, most people who work aren't happy. Most people don't like their jobs. That's never going to work, even if you're chronically unhappy, unless it rises to a different subset. Like I stay in bed all day. Yeah, it gets very complicated. And it's the severity of the autism. If you're able to read, write, and communicate, it might be a little difficult to get the proof necessary to show that you can't do a simple job, not with the public perhaps, so you don't have the anxiety triggered there, one that doesn't make you rush. You don't have to, it's not like a factory assembly line where you have to keep a certain pace, all those kind of things. You have to really kind of figure out why you can't do all 12,000 jobs and cut that down to all the ones that are unskilled, that don't require any prior knowledge. Okay. Heather W. says she had her telephone hearing yesterday. I'm curious why you picked telephone versus MS Teams. Just wondering. It only lasted 20 minutes and the judge didn't ask the VE any questions, nor do he ask me. He said my rep asked all the questions he, ALJ, had. Is this good? Hard to say. I take that back. The fact that he didn't ask the VE any questions is generally very good. They don't really need a VE if someone meets a listing. Could you meet a listing, Heather? Now, letting all the questions be asked by the rep, I do have some judges like that here and there. I kind of tend to think that could be a good sign too, because, or you could just be lazy, tired. But if they're going to initial a dial, they have to be sure that certain questions are answered. Now, granted, your judge said that your rep asked all the questions that I had. It does sound, but I don't even want to say that because I don't know your case. But those two things kind of point to me that it could be a good thing. I'm curious what your reps thinks. Does he agree or she? Right? Richard Unknown is giving some more. He says, work background, 15 years of being a Leo. Well, thank you for your service, Richard. And I see VA. So you're also military. I thank you for that too. That's a big deal around these parts for me and mine, and a lot of people here. So thank you very much for that. Oh yeah, 12 years of military service, 2 years as jiu-jitsu instructor. Oh man, that's awesome. Education bachelor's in CH. I don't know what that is. Communications? No. Something health? VA, doesn't matter. VA won't send me to any specialists he spoke of due to PCP. I don't know what that means, due to PCP. Meaning because they give you a primary, they're not good. So how about you don't go to the VA? If they stink, go outside and get other community care through the VA if you can. Or you have coverage, presumably, maybe, other health insurance. Or maybe you can get it, or maybe you can pay out of pocket. Are you 100% P&T, anything like that? What are your options? And you really need to find out why won't they send you to a specialist. I don't know. I don't recall what you said your issues were. I could try to scroll up here. It's very far up though. Oh my gosh, it's really far up. I'm gonna get lost. Getting in the weeds. Sorry, that's an old restaurant thing. Migraines and chronic fatigue. So you don't have a neurologist for the migraines? You need to, that doesn't seem right. It sounds like PTSD, anxiety, and major depression. So what I meant, a specialist is a psychiatrist, that's a therapist. You don't have a migraine specialist? What's going on with the VA that they're not, is the PCP saying you don't have any of these things and therefore you don't get any treatment? You need to be proactive here, Richard. What's going on? That sounds horrible. And if you have the wherewithal, maybe you have a Leo pension or anything like that, I would be getting care elsewhere until they fix that. if possible. Okay, the VA won't send me to any specialist you spoke of due to PCP not treating me. Well, get a different PCP. You have to be proactive. If you have a PCP that doesn't know how to treat patients, which means you don't really have a primary care physician, then you got to get a new one. That's all that's to that. Therapist already wrote a letter and advised I was not able to work. That's not good. How does she know? Was she also a vocational expert? Wow, what a therapist. I'm being facetious here, just being obnoxious. But do not have any of your providers write a letter saying he is not able to work. Just don't do it. It is rejected by the SSA, and it makes some of them a little pissy because how dare you now take their job away from them by making the conclusion that they're going to go through all the records and find out, and the vocational experts. So it is not something that is well received by the SSA, and it is not something that's even legal to be able to be considered by the SSA because it is reserved for the commissioner, the decision of whether you are disabled from all work. Your therapist has no idea about the vocational requirements for the 12,000 jobs in the national and regional economies, and probably does not have knowledge of all of your other problems necessarily, although maybe she does, or he. Now, if she does, now I realize she doesn't think you can work, but I'm saying she shouldn't be saying it that way. If she says you're not able to work, she has to say, because he can't show up because he has panic attacks and is in bed every morning in a fetal position. He would not be able to reliably attend appointments with me, much less a job. He flips off the handle and verbally attacks people because he repeatedly misconstrues innocuous statements. And this would be, she doesn't even have to say, this would be disruptive of work. So, because she's not supposed to be pretending she knows anything about the work environment, because she truly does not. All she has to do is say what your limits are, not try to make the conclusion of this would do this for employment. And that is not what they want from her or him. She's got to stay in her pay lane. The fact that she thinks you're not able to work is a huge step, though. I mean, that could be a huge part of the battle, because that means she probably would if you knew the right questions to have asked of her on paper and or in a letter. And presumably, if she says that, her medical records are going to be very, very strongly supportive of these limitations and talking about them, right? I mean, my goodness, that's severe if you're not able to work and she thinks so. I would expect that she would be providing some really good documentation about the signs and symptoms that she sees and knows and understands from your history and you speaking in your psychotherapy notes why that would be. So the question is, does she? Because she wrote a letter. That suggests to me that she doesn't think she has the goods in her records. Potentially. Maybe not. So things to find out, though, Richard. Brandon H. says, and I'm just scrolling up, Brandon, to see the first part. All right, this is the ADHD, anxiety, and depression and weekly therapy for 3 years, right, Brandon? He has a CE scheduled for the 5th, and you're scared they're going to die. My caseworker said they were working on email being an option. Email being an option for what? Do you mean a video telehealth CE exam? That is an option with the CE exams for mental. So if that's something you want. Oh, no, I'm sorry. You're not talking about that. You're saying I've had a bad time sending them faxes. Wow, they don't even have email. When you say caseworker, who do you mean? Oh, do you mean are you self-representing and that's SSA? If you have a bad time sending them faxes, maybe consider using a different fax machine. You can also mail them, but anything I mailed them, I would mail certified return receipt, or actually I'd probably UPS it, or do it at least priority mail. Make sure you have the barcode on top and mail it to the address. That way, I mean, they're working on an email being an option. Yeah, that means next year. Potentially. She's talking about the SSA in the big picture, working on different options, which I think is great, and they are doing that. The efficiency moves they're making are stupendous, but I don't know about this one being anytime soon, the email. We'll see. It would be nice. And if I get to report otherwise, that it's came to be, I'll do it here, I promise. All right, 2:37, guys. We've got another 20 minutes. You know, my head's starting to pound, so I guess that's probably pretty good. Kelly Craze, they eat hummingbirds. Don't look at the videos, trust me. And I don't know what you're referring to. Refresh me. God, I'm like a sieve here. Kelly. I probably said something. All right. La Lulu. Oh, yeah. She says, yeah, your ERE record video published for public this morning was available early for members. Yeah, it came. I got the email yesterday, and I immediately clicked on the on button, Lulu, because to me, that was huge. You could tell how excited I was, right? It is huge for us. It really is. She said it was available for early members. Hint, hint for those considering subscribing. Actually, it's not subscribers, Lulu. It's members, because anyone can be a subscriber, but members, they are paid tiers. So, and not everybody can do that, and that's totally understandable. But yeah, you get the videos when they come out, as opposed to sometimes it's a couple weeks later. This one, these guys, the members got it, you know, in 5 minutes, but or maybe it was like a half hour. But the subscribers or anybody else did get it within like a day, because I actually moved a different video that wasn't that exciting, because it really is big, that whole ERE improvement they're doing. And not in 6 months, like next week. Yay. It's pretty crazy. Constitutional Immunity 2.0. You need a podcast, and I want to be your guest. 30 years of this crap, 6 spine surgeries, and the nightmares I want to share. Thank you for what you do. Constitutional, first of all, I love your name, Constitutional, because I'm a constitutional fiend. Back in law school, I was on the Constitutional Law Journal, and I just loved it ever since. I always wondered what it would be like to have a guest that's not a professional in the field. You guys may have met Shanna. She's a representative out of Kentucky, a non-attorney rep, and she's had a lot going on, but I told her for sure I'll keep a spot open for her. And there's a couple other people I just have to organize with, and everything's been so incredibly busy. But I always think about someone who is a beneficiary, but constitutional, I would be concerned, because when you're a beneficiary of disability, now granted, there would be pre-recorded, so there was nothing funky, or some freakish thing didn't come out of your mouth, but for a claimant, I just would not be comfortable with them being on here while their case is pending, because this is public. And what if an adjudication, something they don't like, or, I just feel like, yeah. But maybe someone who was of retirement age had been through the disability process and then has now flipped over to the retirement, and they're never going to be on disability again because they're now collecting it in the name of retirement. Something like that, maybe. But even beneficiaries, I would be concerned about. Although maybe not. We could consider doing one. It would never be live like this. It would be pre-recorded, and we would stick to certain topics and only certain topics, and then we would review it and make sure everything is exactly as we intend. It's an interesting idea. I'm pretty much open to everything, as you probably know. Okay, Platinum says that everything that they requested has been sent, meaning the SSA. I think you're talking about the function report and the work history report, but Platinum, you got to remember that you want ongoing records and treatment. You're still treating, right? Those are fluid. You got to keep sending those in. So if you're doing that, then I understand what you're saying. Waiting over a year, my issue is L5 and root nerve sciatica, lost muscle and loss of function on the left leg to it, walking with a cane. Believe it or not, those cases don't necessarily win. And a lot of it's going to depend on your vocational profile. Yeah, even with walking with a cane. And by the way, the vocational profile of most import would be the age portion of the vocational profile for this particular situation. Under 50, over 50, Platinum, 50. Janelle's talking more about the misinformation in her medical file that was before the ALJ. She said the new corrected information was put in after the hearing, but before the decision. I say give it a try. If you're going to go to the appeals council, and that's a decision in and of itself, right? Then consider doing what we were talking about before. Because it was after hearing but before decision. And I don't know, did you guys tell the judge that? No, you didn't. Well, you must have known it was wrong, because you hadn't gotten the decision yet where he was relying on the wrong information. So you already knew it was wrong. Did you mention to the judge that you're getting it corrected? That could be big. He used a statement made in my notes that was after hearing. The statement was after hearing. After hearing, but the same day my medicine changed. He used a statement made in my notes that was after hearing. So the statement was made after the hearing also. Is that the corrected statement or the bad statement? My medicine changed. It was damaging. The note said I went to a concert 2 years ago. Well, was it 3 years ago? 5 years ago? Did you never go to a concert? I mean, where's the relevance? 2 years ago could be fine if someone only became disabled a year ago, right? And that's not to say that disabled people can't go to concerts, but If someone's saying I'm in constant pain every single day, usually we forego the concert if we're in pain that day. Okay. You're going to hear a lot of barking, guys, because some people are about to come in and the dogs are going to go crazy. West Reputable. Hello, I had my perk interview. Oh, that's good, Wes. That means you won your medical finding on an SSI claim, right? I'm just confused about why the lady told me that I would not receive the full amount until September. I had to notify her of my rental agreement with a family member. Well, I don't know what you told her, so I can't figure out why. Did the rental agreement with your family not start till September? Why? And you're talking about this coming September. So I don't know the details, so I can't really explain why. I would imagine it might have something to do with that. Or do you have some other form of income that will be gone in September? I don't know. Now, if she's picking that arbitrarily, like, well, he told me about the rental agreement. Now, did you say the rental agreement just started now? Or did you say, we've always had this rental agreement, it was verbal, but I can get it to you in writing, signed by the person that I obligated, who's been loaning me shelter, and now I have to pay him back plus pay rent. Does your rent not start till September? I don't know the details there. GC24 style. If the ALJ on 2 different denials states RFC as reduced light work from age 48 to 2, now almost 54, the DDS on last denial gave heavy work RFC. I'm still baffled. Oh my gosh. All right, so let's take this apart. ALJ, 2 different ALJs presumably on 2 different denials. The RFC as light, but a little bit reduced. So not as bad as sedentary, which is why you didn't fall into that 50 to 52 grid, potentially. 48, clearly. If you're reduced light work means you can do all those reduced light work jobs. You just can't do the full amount of light work jobs because some of them would be too heavy for you. Now you're 53, almost 54. The DDS on the last denial gave heavy work RFC. How'd you find it out? Did your lawyer get a copy of the DDE? So somehow he's saying, although an ALJ recently, not that long ago, just a couple of years ago, gave him reduced light work, and then the DDS on last denial gave heavy work RFC. I'm still baffled, GC says. I'd be baffled too. Granted, the new DDS is looking at an entirely different set of evidence. So did you stop treating as much? Did something change? Because he's not, the ALJ's light reduced work is only up until the date of his denial. He's not talking about anything after that. So maybe you improved. Did you have a surgery? You know, to go to heavy though is kind of unusual, but I mean, he didn't even go to medium, according to you, the DDS. So hard to explain why. I think it's a little interesting and looks a little funky, but you know, without all the details, it's hard to say necessarily. West Reputable says, she said I was supposed to notify her before. West, are you saying that you told her how far back your oral agreement for rent has been, and that you have been on the hook for all these months, just couldn't pay it because you didn't have money, but it's a loan and you got to pay it back? Are you talking about retrospective, or are you not talking about that? She said I was supposed to notify her before. So, and no, not necessarily. I mean, yeah, I think when you have a pending SSI claim, you're supposed to remember to tell them when your living situation changes. However, that doesn't, I don't know of a rule, and granted, haven't looked at the specifics of living arrangements for SSI people after they prevail in a while, but she said I was supposed to notify her before, and you didn't, and therefore she's going to what? Personally penalize you till September? We are in May, and you've already prevailed. And SSI goes back to the date they found you disabled, assuming you had already applied by then. Otherwise, it's the date of your application. Is it like a penalty that she's doing? I don't think that's necessarily, I don't know that that's substantiated in the law where she can do that. So that's important. And you might want to get, I mean, I don't handle those things because you can't really hire a lawyer for that. But if it's appealable, I'd appeal it. If what it sounds like is what's happening, but you know better. She said I was supposed to notify her before, so now she's going to stick me with reduced SSI till September. Say what? I don't think that sounds right. Okay. Oh yeah, here we go. All right. So if anyone needs to have their situation evaluated, we can do that. It may or may not get all the way to me. If our category is closed in the particular category you are in, and we can't find a carve out for that, then you'll be notified, and receive an email, probably not from me, probably from Liz or somebody else, but you'll find out and we'll let you know. And, you know, I could always give you the name of someone else. You can do your, you know, see if you like them, you know, do your due diligence and all that. But yeah. And then there's some of you that I say, say the name in the thing. If you and I spoke and I said specifically, say your name, that is because I think we can bypass that. Potentially. The initial. Hi, Heather W says, are bench decisions rare even in an eventual favorable decision? Yes, I've had one. Can you believe? That was like 15 years ago. To me, they're rare. I mean, I don't know, but maybe maybe there's judges that do it a lot, but then there's so many that don't do it a lot. And the reason why I think it's not a lot is partially because they haven't really gone through, the judge himself hasn't necessarily gone through the record as thoroughly as he's going to after he hears your testimony, because the testimony can prompt certain things. I don't know if that's the reason. Plus, it also might be reserved for listing level cases. I'm not sure about that either. It's been such a rarity that I don't really take time to study up on it because it's not something that's going to largely affect my clients. Ton. Yes. Just wondering if you've seen a disability awarded for long COVID. I'd had several. If so, my husband is 60 and got his first denial. Oh, I'm sorry. If you want me to take a look at it, Ton, I know. Yeah, I was having long COVID cases back in, I don't know if as far back as 20, but certainly by 21. I can't even count how many now. Sometimes it's not purely long COVID. Sometimes it's a multitude of other things. At 60, your husband probably has some other issues as well. So your name is Tan. If you want to go to that link I just shared, which if you look in the chat, you'll see it. Mention your name and then give all the information. Give it as if from his perspective. I can reach out to you and, you know, go over a few things. You know, maybe we could see what it was about his, you know, why he got his first denial. And it could at least, if nothing else, give you some direction on some evidence gathering. And then, you know, this is all, of course, assuming he doesn't have a lawyer who can explain it to him. And if not, you know, we can talk. Okay. D, yeah. D with the heart transplant. I'm glad you got it, D. Okay. So Kelly Kreis is, just to refresh, I believe, was the one asking about the medical treatment gap because there was an insurance gap from December to May. That's not the worst gap ever, Kelly. If you said a 2-year gap, I was going to be a little concerned. That is a completely understandable gap. And you're back in and getting treatment starting May, right? So I wouldn't, you know, definitely be aggressive with getting treatment, you know, be very proactive. But that gap alone, given the obvious, the move and Medi-Cal now to Medicaid, that's, it might even be clear on the record, but if not, you can certainly make a note that if you go to a hearing, you mention it. Again, a lot of these things are what's going to be relevant at a hearing, not necessarily before a hearing, because they are more of, we perceive them as like they have to find the check boxes have been met from an objective medical evidence standpoint. And there's going to be none from December to May, but there could be some before and after, and you're not going to have an issue. It's certainly less than a year. So Kelly, go ahead and make sure you start getting treatment now, in therapies, everything, whatever your issues are. Yeah, D, I thought, 100. I thought someone mentioned 800. Was that you or somebody else? And I saw the 800. Did it make it sound like I said 100? I'm sorry. I'm maybe a little stuffy. Okay. Kelly's saying that I'm just going to bring this up because this could be relevant for a lot of you. My first doctor appointment is in July. Okay. If you can get something sooner, get on that cancellation list, you know, because then you can get all the referrals sooner. You're going to need specialists, all that kind of stuff. Sometimes if you say, do you have a cancellation list? Can I get on that? And sometimes you can get an earlier appointment. But otherwise, you keep that July appointment for sure. John, gone. I'm not putting that up there, but thank you. That's very nice of you. I feel a little beat up today with my head, but it's starting to wear off, I guess. So I'm feeling it really good. I'm Williams. I just want to make known using Miss Joy and Dr. Ed Weir. I'm not sure if I'm saying that right. Info. I got approved in 5 months, did have current x-rays and MRI results from primary care, but didn't get denied first time. I am so glad, and I appreciate that. I'm very glad for you. Second phone. Will the ALJ deny me if mental health and physical disability without a psych hospitalization? Not necessarily, not at all. There's so many other factors. You will hear many of us talk about how difficult it is to win on pure mental. If we don't have severe mental, that would be enough to make us have to go to a hospital. Otherwise, if we're able to manage on our own without it, maybe we could, do a simple unskilled third grade job. But that's not the case. You don't need anything that severe of a mental issue if you are, for instance, seeking to meet the grids based on your physical disabilities, and your mental health may affect things like transferring your old skills you used to have at the job, one of the relevant jobs. So most of my people that have a combo do not have a hospitalization. And of course, we win. So just saying. Yeah, Kelly, praying mantis. How does the big new bill affect folks on disability? Not at all, thankfully. Well, except that it's going to be making things probably go a little faster, perhaps. But that's really not the big new deal, big new bill. That is more of the SSA having more incentive and maybe support in using technology to expedite things. Like that ERE thing that I was talking about before. It's huge. I mean, it takes, so many of these things are going to take work off of their workers and put them on us, which is why some of my side of the fence, of the rep side, doesn't want some of these things, because they don't want that responsibility, because they want the easier job. I am not for, putting everything on reps either, but giving us access to our clients' cases and seeing, so we can keep oversight over the progress of the records development, so we can see what needs to be gotten, so we can go get what's missing, or there's so many things. Even like, we can do this, of course, now, downloading the CE exam nearly in real time to share it with our client and say, did he do this? He says he did this. Did he do this? Did he test it? To go over things. Otherwise, there's no way to know until you're heading to hearing. So, but that's really, I think, more of a prioritization point now that's being had that we didn't have before. There was really nothing being helped to help the system run faster. They did some things that helped pay out more money and deplete it faster, but not by finding people disabled more or anything like that. So it was all other things, some of which I knew was going to be really helpful to some people, but maybe not very wise in the big scheme of things. But that's something for a different day. You're welcome. Still plugging along. Neolog. Pain management gives me gabapentin because I can't take epidurals. Yes, I have twice a year visit with my general practitioner. Good. See, that's pretty good. Gabapentin because I can't take epidurals. You getting diagnostics updated? Is it the kind of, impairments that diagnostics should be updated? Because people's bodies change just based on a passage of time alone. They need to be doing these things, in my opinion. Tiffany's addict. Daughter diagnosed at 11 years old, chronic headaches with migraine. Oh, poor baby. Over the years, developed vertigo and fibromyalgia. Hasn't been able to work. Tried vocational rehab to get training, but they said she isn't a reliable worker because of time of recuperating. Of course, she wouldn't be. Do you ever get letters? You have a letter from vocational rehab about the fact that she wouldn't be a reliable worker. So is that they don't want to expend the resources on vocationally rehabbing her because she would not be able to reliably keep a job. Second denial appeal filed. How old is your daughter now? It's hard with the young people. I assume, Tiffany, if you haven't already, but if not, do it. She needs a migraine specialist. She needs a vertigo specialist, a fibromyalgia specialist, which is usually a rheumatologist that is very fibromyalgia literate. Not one of the ones that aren't, because some people have a bias with it, right? Yeah, I would get all that. The journaling for the migraines and the headaches, the vertigo, how bad is that? Is she on medications for it? And is there anything else? It's going to take a lot of workup if she's young. And I feel for her, because it's obviously really, really affected her whole life, right? When it starts as a kid, it's really kind of crushing. So hang in there, Mom. I'll take it, Umo. Umo says that my staff and I are a complete game changer in getting help for filing for SSDI. Well, that's the way it's got to be done, right, Umo? Oops. All right. I don't want to repeat. Let's see. I used to work for SS Attorney and have gotten info for recon and information that has just been revealed. Just wondering how difficult it was to get S with else, or just failed to find out. Thank you. All right, so you know what you're doing. All this stuff is not Greek to you, Ton, right? I forget all your details. I know your spouse was 60, right? I forget. Let me just scroll up. My eyes will work. Ton. Oh, long COVID. He'll see, yeah. Yeah, well, you know what to do. Good luck with it. Good luck with it. It can be, and as you know, his age is going to be helpful versus, being 11 years younger or even 6 years younger. Okay, West is talking about, this is about SSI, guys, and the living arrangements business and the rent. And I'm just scrolling up, West, to see, you had said something up here, I think. It started in March. You filed in March? Oh, no, the rental agreement started in March, and she's saying she's not giving you credit for it till September. That sounds untoward to me. You have that in writing from your landlord that he's been charging you all along. Maybe he's let you not pay because you couldn't, but you're going to pay him back. Is that what it is? Or were you paying him in March because someone was giving you money to pay him, which is a different story if that wasn't a loan. And you said you used your grandmother's address even though it was a temporary. So meaning like you told me you lived at your grandmother's when really you moved out in March with this other person. Is that what happened? Yeah, hard to see. I'm not sure of the facts here, West. Neolog is saying that he can't take epidurals or any shots because he can't stay still for them. They call it involuntary movement. Okay, I would get proof of that. Is that a diagnosis as to why that is, right? As opposed to you just saying it. You want that to be in the medical record. It can help because whatever causes the involuntary movement might actually cause you other limitations that you haven't been thinking of, Neolog. I bet you couldn't be a fine brain surgeon with those involuntary movements. What do you think? Maybe not a knitter either. Do they have that job in there? I don't know. All right, Tiffany's attic, daughter's 28. That's the daughter that was disabled since 11, right? Age 11. I had a case, Tiffany, of the young person was now like 19. This was right before COVID. Yeah, maybe 2 years before COVID. I remember specifically where I was when I was conversing with the mom on it. I was at a CLE actually in person. Now we do most of them online. But that wasn't long COVID, obviously. But she had gotten Lyme's disease as a child. And you want to talk about a train wreck of what it did to her body and then her mind. And I don't mean to make you nervous, but it was vertigo of a severe, and the vertigo also takes everything created this like she also has like Ehlers-Danlos in it with the hypermobility. All these things come out later. We did prevail, but we had to go the very, very long haul. And a lot of specialists. And I had to always be nagging about just try to get her into occupational therapy for that vertigo, because the more you do for it, the more there's going to be evidence of how bad it continues to be. Gosh, it just kills me. It just kills me. The unfairness of life, of course, right, guys? Yeah. Hang in there, Tiffany. Keep fighting. By the way, Tiffany, if she can get an accommodated job where she can work flexible hours, and because if she's already been doing that, she might have her own work record for SSD, right? Not have to be on SSI when she does eventually prove disabled. And then if you really are lucky, you can prove she was disabled before age 22 and she can get DAC. But I think you said she was already denied by an ALJ, like a permanent denial? If not, then DAC is off the table, but she can still prove going on. And if she works those little bit in an accommodated job with someone who will spell out the accommodations, like she doesn't have to come in that day if it's a day that the vertigo's there or whatever, and she only works 3-hour shifts. And that's, by the way, what this young person did, except it never was even enough to get enough credits, even at that tender age. But she will be able to get DAC now when one parent becomes retired, disabled, or passes away. So that was a big, major goal of mine, besides just securing SSI for her. It was that future of a better amount not being subject to SSI rules. But it was a lot of specialists. But your daughter, if she could do a job and earn, right now it's still under $8,000 a year, working here or there. And, it doesn't take that many hours to do that. even with a relatively low paying job. So, and the proof of the accommodation would help prove that this could not be full time, blah, blah, blah. So this is not indicative of not being disabled. That can really help her future if it's something that if she thinks she can do to keep her credit, so that as while she keeps fighting the big fight, she's never going to become non-disabled. I'm sorry, she's never going to become uninsured where she's stuck with, SSI or whatever's left. So, and plus it'll help her grow her SSD amount so that it grows over the years as she continues to add to it by working versus not working. Because it's what we pay in is what we get out of it. Anyway, I love seeing people not on SSI and getting SSD Medicare instead of Medicaid and all that stuff. So Heather W says, and I got to get off soon, guys. It's 3:11. I have an actual colleague meeting. It's not quite yet, but I have to go take a breather soon. My head is starting to hurt after that procedure right there. Purely superficial, I might add. It's not my brain. Heather says, sorry, Lulu, I just skipped over Heather by accident. I was inpatient for major depression and more mental health issues 2 years ago. I'm very sorry. When you say it's stronger to have a physical impairment, does that include migraines? Document to confirm? Yes. Yeah, migraines is quite physical, and you want to have robust migraine treatment. Unless they are like twice a year, in which case they're not disabling. If they're the thing that happens multiple times a month, I would definitely be working that up big time. And again, depending on your age, your vocational profile, that all comes into play here. It all comes into play. All right. So Lulu says, thank you, Attorney Joy, for keeping your head in the game despite personal ailments with us today for this. Oh, thank you, Lulu. I appreciate. Yeah. I was so relieved when I found out the thing was happening at 8 a.m. It was an hour away. I had to get up early and get out the door, but I was like, I'm going to not miss this. West says that he never received any money for the loan from anyone. It was a verbal agreement. Right. People would be like, well, you could stay here. And then you make this agreement, like verbally, like, listen, thank you for letting me stay here. I will pay you rent. I'm not taking this, I don't want to mooch off you or whatever. And so you have to agree that it's like worth $500 a month or whatever, blah, blah, blah. And that's a verbal agreement if you both agree. And even if you don't talk about it again, and then you can document that there is a form. And it sounds like they got it and they agree. They're fine with it. They have to accept it, that the other person signs and says, yeah, I've been loaning him this rent. This isn't a gift. This is a loan. And he has to pay me back, blah, blah, blah. And we do that so that their back benefits properly reflect that they're not to be reduced by the third, because that was a loan for the last 3 years. And sometimes it's only appearing now because, when they fill out their SSI application, they don't even think about that question or answer. They're just like, my uncle gives me a room, or I live at my uncle's, and they don't go into rent because they're not actually paying it. They don't see it that way. But meanwhile, they had this whole discussion and arrangement. So I never received any money for the loan from anyone. It was verbal agreement that turned to a written agreement. She never asked for any copies of the letter, but she did ask for my mom to confirm. So she took a verbal confirmation from your mom. So it's your mom that has been putting a roof over your head since March with the agreement that you'd pay her X amount per month. If that's correct, and there's no other reason for that September thing, I would be like, no, this started in March, not September. Again, I don't have all the facts, but if that's what's correct. So Tiffany says, due to the pain in her arms and neck, she can't do regular repetitive movements. So that would be, through what specialist can you prove that? Get her there. That would probably involve lots of PT on and off. Consider doing that. Occupational therapy, maybe. I forget what causes the pain in the arm and the neck. Yeah, so Tiffany's saying that they went to vocational rehab for her daughter, young adult daughter. Oops, wrong one. Sorry. Makes sense what you're saying. She says we went to vocational rehab to see if there was something she could do. We just haven't found anything. Right. The young person I was talking about actually worked very part-time. And this is before she overly decompensated and had to be put in a psych ward and stuff, with a family, like an aunt in her store. And she had to do things very special. I got a whole letter from describing the special accommodations, which were both in terms of dealing with the public and things she couldn't lift, so other workers had to do it for her, and things of that nature, and the short nature of the shifts, because too much time on her feet and not being in a position for this horrible vertigo. Vestibular something, Tiffany, was a vestibular whatever with the vertigo. And the employer, which flat out was the aunt, but nothing was being hidden there, but she wrote a very articulate letter, and I think that helped too. And by the time we got to hearing, she hadn't even been there in like 2 years. West, he's confused because the lady wouldn't tell him how much. You said that July's, see, I thought you said September before. It's kind of hard to go over these things blow by blow, West. Like these live Q&As are usually best for quicker questions, more of policy and, rules and stuff. Unless it's like super quick. He was told by his lawyer, however, it's prior to the PERC meeting, that he would be entitled to the full SSI amount a month, and the HRA would be taking from my back pay. HRA? Is that some local benefit you got to pay back? But that's just back pay, not my monthly benefit. Yeah, not sure there. All right. Yeah, again, I can't really go into that too much, Wes, because I don't see everything in front of me, and so I'd be kind of basing it on such reduced information than I would need, because SSI and perks is very, 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 very specific. So it's kind of like I'm not giving you any clear information, and that's not helpful to you and taking time here. Okay, guys, it's 3:18. I'm going to split. Thank you so much for coming. And as you know, 9 o'clock in the mornings, we have our video coming out every day. Whatever share was going on at the time, I pop it out, usually from the work day. And then, but sometimes just other Q&As. And then, of course, Wednesdays at 1 p.m. Eastern Standard Time, we have our live Q&A session. So good to see you all, and I hope to see you next week. Bye-bye now. Take care.